like to pass the floor to Mr. Aljosa Petek, who's a lawyer from Slovenia, from PITS, and Aljosa, you would like to speak about corporate responsibility and climate change. Thank you. Do you have your slides, or you will share them? Thank you. Much easier.
Okay. Can you hear me normally? Is everything all right? So I'm gonna guess yes, and I will continue. So my name is Aljosa Petek. I'm an environmental lawyer and activist from Slovenia, from PITS, a legal center for the protection of human rights and the environment. So as our relatively long name suggests, we work on these two fields, but they include asylum and migration, social security rights, family violence, children's rights, protection of democracy. And then myself, I work only in the environmental field or the department most of the time. Here you have a little picture of Slovenia. If you ever checked Slovenia on a map, or if you visited us, we do look like a chicken. So if I continue, today's presentation from my side would focus a little bit on the corporate responsibility regarding climate change. Within the projects we performed with it, Justice and Environment, we had this opportunity to really research this topic, and we had some interesting findings. As everybody knows, the corporations, especially the carbon majors, have a huge contribution to climate change. These contributions have been studied several times and a lot of times already. While we are used to this state responsibility, for handling climate and so forth, more and more obligations are being transferred to companies, to really large companies and corporations. So this is something that is happening right now. And the corporation should be, let's say, responsive to market signals. Climate change is the greatest and widest ranging market failure, as the Stern Review states. And as we in advocacy tend to speak quite often with any meetings with decision makers on the state level and so forth, the benefits of strong early action on climate change far outweigh the cost of not acting. And this has already been proven several times. Corporations and truly large companies also have a substantial amount of money and funding, even on a national level, even in a country like Slovenia. That could and should be invested, of course, for the sustainable transition and for handling the effects of the climate change which are going to happen no matter what we do at this point. So here is just a short graph representing the biggest companies in the world and their contribution to greenhouse emissions. So this is really a huge contribution overall. According to a new analysis, actually from this year, 70% of CO2 emissions from the year 1751 until now can be attributed to only 78 corporate entities. Here we have another picture. As you can see from the table, this was made by Climate Analytics. The financial gain of carbon majors is truly enormous. From 1985 to 2018. 12 of the most polluting entities achieved $21 trillion of profits, while this caused estimated damages of $15 trillion. So the responsibility here is quite obvious. And while scientists continue to evaluate the social cost of carbon and even put a number on it, only a predicted third of this price in practice is attributed to the actual corporations, while other majority, or the huge majority of it, is still allocated to consumers and, of course, the states. So now I'd like to share a little bit about public opinion on these matters in Slovenia. In the year 2023, our partner organizations did a little research of public opinion poll. And 83% of Slovenian residents support legal responsibility of private and public companies to reduce emissions in line with the Paris Agreement. This research was done in Austria, Belgium, Finland, France, Germany, Ireland, Netherlands, Poland, Spain, and of course in Slovenia. A similar amount of people believe that the banks are also responsible for the actions of companies in which they invest or financially support. Then a little less than 3/4 of people believed that people should have the right to directly sue large emitters of greenhouse gases for compensation for damages done to them through the effects of climate change consequences. such as floods, droughts, heat waves, and everything that we are experiencing in the last years. And then I have to mention as well, we did a public opinion survey within the DACE project as well in Slovenia. And here we can see that 68% of the Slovenian, on the other hand, believe that it's the state's responsibility to protect citizens from negative consequences of climate change. So here we have a little bit of contradicting opinions, but we see that people are basically focusing on corporations, on companies, and then as well on the state as the responsible actors within this within climate change happenings. So in August 2023 in Slovenia, we had huge floods. I know there were a lot of natural disasters and damages also this year and last year in other countries across the EU and across the world. And what happened in Slovenia, interestingly, you know, if I continue from the public opinion on the last slide, civil court cases arose in Slovenia against state institutions and municipalities because they're the ones who are supposed to provide protection for the citizens and the residents. And there are no consideration actually of suing the greenhouse gases emitting companies or engineers or subcontractors of anti-flood measures who basically did not take into account, you know, the projections of climate change and what the things that were known are going to happen, but they simply didn't consider it. So this is an interesting development, for example, in Slovenia. But when it comes to human rights in economy and also considering climate change and climate rights in economy, we do have in Slovenia a national action plan from 2018 for enforcing human rights in the Slovenian economic system and businesses. It was based on the UN guiding principles. So we currently have these three pillars set up. The state is responsible for adopting a legal framework based on which then the registered companies are responsible for upholding human rights in their business practices. And the state is responsible, of course, for control and sanctioning, which is a very important pillar, as you might all agree. There are several areas in which this action plan is designed for, so equal opportunities, basic workers' rights, environment protection, sustainable development, prevention of human trafficking, and so forth. It was signed by 30 Slovenian companies. I checked this list yesterday again and checked how many of them are publicly owned, and it's more than half are publicly owned. So we're not quite on the way yet, and also the legislation that was promised in this action plan is not yet adopted. So in general, let's say from the world perspective, we have the general civil liability, which mostly arises when corporations and big companies act and do something that comes from their negligence, nuisance, infringements of personal rights, but also sometimes trespass is being used. We have the huge issue of the costs, as you may all know, when we, before 2022, also in Slovenia, if we sue the private company, if we lost the case, we had to pay the opposite party's costs, the legal costs, and some other potential costs. In 2022, actually in Slovenia, we adopted the new Environmental Protection Act, which was based on a huge civil society victory. And we adopted a new article which actually prevented this from happening. So if you sue a private company, climate matters, environmental matters, and so forth, you do not have to pay the cost of the opposing party if you obviously didn't go to court for no reason whatsoever, if you didn't trick the court, so to speak. There's also the question of court jurisdiction in these civil cases, but these questions already and always depend on the plaintiffs and the respondents in question. One of these cases, I'm sure you're aware of it as well, is the Milieu Defensief versus Royal Dutch Shell. For instance, the plaintiffs had invoked the rule of jurisdiction where the damage occurs to establish some jurisdiction of the Dutch court. But these cases, of course, vary from case to case. So I will not go through all of these cases, which are actually very interesting. This one is about a farmer in Peru who sued the the company which provided electricity, the biggest provider of electricity in Germany, and so forth. These cases are still not over. Okay, developments overseas, but maybe we can discuss a little bit more. All of these cases are happening. We are aware of all the cases that are happening against corporations and companies as well. But the EU is currently in the process of acting on it. And one of those actions, of course, is the new directive on due diligence. EU has adopted legislation addressing the due diligence of large companies. Due diligence here means to identify, assess, mitigate, report on the human rights risk associated with their operations and across their value chains. This may prove very difficult to enforce in the future. We will see how everything is going to happen, but the due diligence principle does arise from soft law, from OECD guidelines, from UN guiding principles that I already mentioned. It can be a civil obligation or a statutory obligation, is being transferred in the EU. And as I mentioned, the enforcement can be problematic, and we will see what happens with these things in the future. So the directive was adopted this year. Next to the due diligence provisions, companies also have to adopt and put into effect a transition plan for climate mitigation, which is compatible with the Paris Agreement goals and the 2050 climate neutrality target. So this is quite a strong plan that the companies will have to prepare. There is a strong emphasis also on monitoring. As we see on the national level, it's always a problem with implementation and monitoring and sanctioning, and the member state shall ensure that the supervisory authorities have adequate powers. And we will see again how this transfers into practice. One thing that is also very interesting, also from the national point of view, are these pecuniary penalties, which are based on the company's worldwide turnover. So this is very important. This can be above 5% of the net worldwide turnover of the company in the financial year that is preceding the year when the penalty was imposed. Maybe a little bit just about the scope of these companies and partnerships. These are companies with 1,000 or more employees and a net worldwide turnover of 450 million euros that will have to oblige with these new provisions. I checked again the list yesterday in Slovenia based on information from 2018. This will be 4 Slovenian-based companies, but this act is targeting approximately 17,000 companies across EU and outside who have the turnover, of course, then in Slovenia or, the countries within the EU in this case. Okay, the Companies Act in Slovenia, for example, is now also transposing the Company Sustainability Reporting Directive, which I'm sure you already know about. But this year, companies are already starting the report. With the 1st of January, they will have to report on their required social and environmental information. So we will see again how this occurs, but so far from the national point of Slovenia, we don't have this transposed in a way where it would be actually fully obligatory from the national law. But I did input an important provision from the Slovenian law. For example, a person who was convicted of a criminal act against human health or the environment cannot become a founder, partner, or an entrepreneur of a company. I am not completely sure if this is fully followed in practice in Slovenia, but yeah, this is one of the general provisions. Then maybe when it comes to disclosure of climate-related risks, which basically the due diligence and corporate sustainability reporting directive also try to achieve, I would like to maybe notify or talk a little bit about this case of Pacific Gas and Electric bankruptcy. So in 2019, the first climate-related bankruptcy occurred when a utility company, Pacific Gas and Electric, was faced with liability for wildfires in California from their faulty electrical lines, and the damages were estimated to be around $30 billion, which were exacerbated by the heat waves caused by climate change. And then based on such thing, a task force was founded, and then we have the Corporate Sustainability Reporting Directive and also the EU Taxonomy Regulation, which stresses the use of cash further by the companies and so on. Then we have a very important and for me very interesting situation as well, when some entities, NGOs or shareholders basically are using corporate law to let's say control the actions of the company. Corporate law is particularly interesting in this way. There is an increasing concern, as you all know, that fossil fuel investments are stranded assets which become economically unviable. I have an example here from Slovenia. This is the infamous thermal power plant in Tesh, which decision for it being built was in 2004. At the time of construction, it was supposed to work till 2050. Of course, now it is going to be closed by 31 or before because it is making more than 150 million euros of losses per year. And now this was by the public, was owned by the public energy company in Slovenia, and now it's being transferred into the state's property because it makes so much loss that the company is not able to finance it any longer. So we have a very, let's say, specific case of how you should not invest into fossil industry anymore. At this point in time as well, we see that there was so much greenwashing and so on. I will talk about a little bit about this as well. So there's also the consumer protection from greenwashing from the big companies and corporations, prohibitions of unfair commercial practices, and obligation of enterprises to communicate in a non-deceptive way. Here we have two examples. The FIFA World Cup from 2022 was supposed to be climate neutral. Of course, this was proven not to be so. And on the left side, we have the BP advertisement. 96% of BP's annual spend is on oil and gas, and here they were stating that they're working to make energy clearer and so forth. So these are really visible examples of greenwashing. In Slovenia, of course, we have some consumer protection legislation protecting or regulating marketing, deceptive or unfair business practices, false information of emitters or information. But on the level of EU, we now have the directive regarding empowering consumers from the green transition. So it's protection against unfair practices and providing better information, and it will be reinforced further by the proposal for the Green Claims Directive, which again is countering this greenwashing done by the countries. Okay, here we have there's a plethora of cases.
I do apologize.
Yes.
Ayosha, can you wrap up
Sure.
a minute? Thank you. Sorry.
I'm done. I'm sorry. The main takeaways here would be that the corporate liability regarding climate change is growing. There are important statutory developments, which I've mentioned. I would also like to explicitly talk about just a little shortly about this, that there is a correlation between litigation and stock value, that there's also research done that shows that even if a climate lawsuit is being filed against a company, the stock prices already descend. So with this, I would like to finish. Thank you.